Now there are certain exceptions where the company is not required to issue any prospectus. So this is the first, where the shares are given to the existing shareholders, so or existing debenture holders. So then full prospectus is not required, only an offer document is to be made by the company giving the necessity of raising this fund, how many shares are issued, because when you are issuing shares or debentures to existing debenture holders or shareholders, then they have to be offered in proportion to their shareholding or their loan in the company, in the company. So that is how the company decides the proportion. So no prospectus is to be issued, but an offer document has to be sent to them. And then in the case of where shares or debentures were earlier issued and they are already listed and they are uniform, the new issues also uniform in all respects with the existing shares or debentures, then the company is also not required to issue any prospectus. Now let us come to the deemed prospectus. Now any document where a company is giving offer for sale, that is also deemed to be a prospectus, because in case of offer for sale, one existing shareholder through the company is selling its shares to the company. So this is offer for sale by existing shareholder of the company, but the document which is made through which the public is invited to subscribe for these shares, that document is also deemed to be a prospectus. Now let us understand what is a shelf prospectus. Now shelf prospectus is meant for those companies or public financial institutions or scheduled commercial banks which are frequently raising money from the public. So if you look into the financial institutions or the scheduled banks, all of them, they are raising money because they have to give this to the other people who require money from the banks or the loans from the banks. So they have to raise frequently public money from the public. In such a situation, every time they have to make a prospectus. So a facility is given to them that they can make a shelf prospectus for with the tenancy of 1 year. So in that, during that year, company can raise company can raise 3 or 4 3 or 4 times the public issue through the same prospectus. So shelf prospectus is like a prospectus or the information which is lying on the shelf in the office of the registrar of companies. So once the prospectus has been filed, so during 1 year the company can go ahead with 2 or 3 or 4 depending upon the need of the company for the public issues on the similar type of shares or the debentures for which the shelf prospectus has been made. They have to be uniform. They have to be uniform in all matters which are given in the shelf prospectus. So the company is not required to every time to write prospectus and submit it to ROC. Now over here, but the thing which has to be maintained by the company, that let's say that company has come up with one public issue. Now after 3 months, the company goes ahead with second public issue on the same shelf prospectus. Within this 3 months, whatever changes in the financial position of the company has incurred, or there is any information which the public should know, that information should be filed in the form of information memorandum to ROC, so that the necessary changes can be made and this information can be circulated to the public also. So this is the requirement in case of a company goes for shelf prospectus. So let us now discuss the red herring prospectus. Red herring prospectus does not have the quantum of the securities which are being offered by the company, and also does not have the final price of the securities. A price band is given in which through the book building process the bids are invited from the public, from the prospective buyers or subscribers to the shares or buyers of the securities, that they want to offer within the price band, and on the basis of the offer, then later on the price of the securities is finalized and then the final price is quoted in the full prospectus. Otherwise, in all other respects, the red herring prospectus and the full prospectus remains the same. If there is any change in the red herring prospectus, that change has to be notified in the full prospectus. What is abridged prospectus? Abridged prospectus is a short prospectus which contains only the salient features of the prospectus. Now prospectus is a document and it is not possible for a company to give prospectus to the huge prospectus to everyone, because a lot of expenditures is involved in printing such kind of a prospectus. So The Companies Act gives this privilege to the companies that they can make an abridged prospectus which contains salient features of the full prospectus, and they can be issued along with the application form to the prospective investors. So, if any investor wants to read the full prospectus, he can write to the company and get the full copy of the full prospectus. So, this is what is meant by the abridged prospectus. So, we have discussed what is prospectus, shelf prospectus, red herring prospectus and abridged prospectus. Now, this prospectus, as I told you, all this information which is given by the company in the prospectus has to be true information, because public is at the mercy of the promoters of the company. What they write in the prospectus, on the basis of that they invest their hard-earned money. So, the golden rule of public deposits, it says that the public is at the mercy of the company's promoters. So, whatever is stated in the prospectus should be stated as scrupulous and as accurate possible. So, that is why there are liabilities which are put up on the promoters of the company or the directors of the company if the prospectus contains any untrue statement or any misrepresentation or any false statement. So, let us now discuss the liability for misstatements in the prospectus. So, first liability is in the form of tortious liability, which is given under the heading of damages for deceit, and the most important case and the leading case over here is Derry versus Peak. Now, in this case what happened, there was a company which used to run tramways through the mechanical power. So, the company wanted to have sanction for running the tramways by steam power, and the company had applied for the sanction. So, two sanctions were required. One was from the Parliament and another was from Board of Trade. So, the Parliament had given the sanction that the company can go ahead with running tramways with the steam power. On the basis of this, they issued a prospectus where the directors had written in the prospectus that company has now the necessary sanction for running tramways with the steam power. So, the company will be a profit earning company and the huge profits will be gained by the company. So, on the basis of this, the shareholders, they applied for the shares. Later on, the Board of Trade refused to grant this sanction to the company. So, few shareholders, they sued the directors of the company that the directors, they had given a false statement in the company, due to which the shareholders, they have faced loss, because the company has not got the approval for running tramways by the steam power. So, over here the directors were not held liable on the ground that they had this honest belief that the approval by the Board of Trade will be given, because once the approval is given by the Parliament, the Board of Trade will definitely give the approval. So, there was an honest belief that this approval will be given. So, the directors were not held liable for compensating the shareholders. Now, this created a lot of problem, because on the basis of honest belief, the directors, they were able to save themselves against the disputes which were raised by the shareholders for the false statements which they had made. So, that is why to take care of this issue, a requirement of compensation was fixed up, which is in the form of civil liability under section 35, that even if the directors have the honest belief but the statement is false, they will be held liable to compensate the shareholders. So, every director of the company, every person who authorized himself to be named as the director of the company, every promoter of the company who is named as promoter in the prospectus, and every expert who has consented to give expert opinion on the prospectus, all four of them, they will be held liable to compensate the shareholder and shareholder who has suffered loss due to the statement which was false, and their liability will be joint and several liability. So, this is how the problem which was created through the decision of Derry versus Peak was overcome by putting this section of compensation under section 35 of the Companies Act. Next is a rescission for misrepresentation. This remedy lies in the hands of the shareholder. So, if he wants to take back his shares, he can apply to the court for cancellation of his contract of shares. So, he will return the share certificate to the company and company will refund his money back to him. But obviously, there are certain precautions which have to be taken by the shareholder over here. There should not be undue delay in that. shareholder should not affirm that he has received and now he is going he is keeping with his shares, and also the winding up process should not begin in between. So if the shareholder affirms, if there is undue long delay for offering for rescission for misrepresentation, or the winding up of the company has started, then this remedy will not be available in the hands of the shareholder. The next remedy is in the form of criminal liability, which is given by section 34. So over here, if any false statement or any untrue statement is given by the directors of the company, then they can be held liable under section 447 of the Companies Act 2013, which deals with punishment for fraudulent purposes. So this is a common section which applies at number of places. So even if a person gives a false statement, even if the false statement relates to the prospectus, the directors and promoters, they will be liable for this and criminally liable for this under section 447. So the false statement or untrue statement can be false in context, it can be false in form, it can be untrue, or it can be also misleading. So if it is misleading and due to these statements or the misrepresentation, if the investor is misled for investing in the company, then the directors, they can be held liable under this particular section. Now what will be the defense to the directors? They can say that the statement was immaterial or the fact was immaterial. Then they can say that they honestly believed, and till the time of the issue of the prospectus, they believed that this statement is true. They can also say that the person did not authorize the prospectus containing such untrue statement or misrepresentation, and when he came to know that this has been published, he gave a public notice of this. Or he can also give as a defense that he was not the director of the company, and when he came to know that his name has been put up as a director in the prospectus, then he gave a public notice of this. So these are few defenses which are available to the persons when they are criminally held liable under this particular section. Then another last remedy is under section 36, which is about punishment for falsely inducing persons to invest money. If any person is inducing any person on the basis of the false information to invest money, then this can also be punished under section 447 of the Companies Act.